a mistrial. And then in 1995, that was a second trial that began. A year later, Lyle and Erik were convicted of 2 counts of first-degree murder and sentenced to life in prison without the possibility of parole.
So then we fast forward to last year. The brothers they filed a motion. They sought a new hearing based on what they called new evidence that appeared to support the claim that they were being sexually abused. That brings us to today. The fate of the Menendez brothers, now 56 and 53 years old. In a manner of speaking, it lies in the hands of the DA's office. And I say that because ultimately it will be a judge who makes the decision. But if George Gascón decides to present a resentencing recommendation to the judge, that's what the defense wants. So there is the possibility that a judge might agree with both of them.
And while we're waiting for this news conference to begin, we're going to check in with Joshua Ritta. He's a legal expert. He joins us live to analyze what could happen next in this case. Thank you so much for joining us. So what do you think will happen today?
Well, I can't imagine that we're going to have all this fanfare. This is now the second press conference in about as many weeks' time. Without this being a pretty significant announcement. So I think that what we're going to hear is that George Gascón has agreed with the evidence presented to him through the defense in that habeas petition, and he's decided to go ahead and join with them in asking for a resentencing on both of the Menendez brothers.
And that's something that's critical, isn't it, Josh? I mean, you know, we've heard so many different people say this is the Gascón decision, but it's not. It's a judge's decision. But as you point out, when you have both sides of an argument coming before a judge saying this is what we'd like, that carries some weight with the judge, doesn't it?
Absolutely. You are correct. They're joining in a request of the court to have them resentenced, but ultimately a judge is going to have to make that decision based upon the motion, the facts, the law in front of that judge. But when you've got both the DA and the defense asking for the same thing, I think a judge would be hard-pressed to deny that.
Now, some people believe that District Attorney George Gascón's decision to reconsider this case could be influenced for political reasons, like wanting to show he cares about fairness in the justice system. Others might think he believes that perhaps this sentence was too harsh. What is your opinion on this? And especially since his opponent, Nathan Hochman, has not made any announcement about this.
I will say that I'm not a political strategist, but the timing of this is very interesting. The habeas where this new evidence was turned over to the DA's office, that was filed back early of 2023. So they've had this in their hands for some time, but it's now October before a November election in which we're hearing this announcement. So it's hard to say that it doesn't play any role, but you're absolutely right. We've changed culturally, certainly our view towards sexual assault as it relates to males being the victims of it. I think all of that has changed, and I think he's decided that their case deserves another look.
Well, let's talk about that if we can. We're still awaiting George Gascón to come in and make his announcement, but Joshua Ritter, a legal expert, is here with us. And Joshua, the thing that keeps coming back to me is, yes, we are in a different culture. And some 300 cases have been approached with Gascón about resentencing. But how do you retry a case, in essence, that is 35 years old? It was a deadlock. It was a hung jury, the first trial. Then there was a conviction. But now we're retrying it, in a sense, again. And many of the parties are not even with us anymore.
No, you're absolutely right. It isn't a retrial. It's essentially him using his power invested in him as the DA to request this of the court. Again, he doesn't have the out-and-out power to do it with the snap of his fingers, so he does have to get a court involved. But you're right. He is taking it upon himself to reevaluate this evidence. 30 years ago, a jury heard all of the evidence and decided that they were guilty of first-degree murder. Now, Mr. Gascón has decided that based upon, perhaps in part because of this new evidence, perhaps in part because of our change in views culturally, that he feels a more appropriate sentence would be manslaughter, if that's in fact what he's going to announce, which means they would already have credit for time served, which means the next order, if the judge grants this, the next order out of that judge's mouth will be to have them released.
I'm very curious if there are other precedents set that could influence this particular case in the Menendez brothers, particularly regarding like courts' view of mental health and childhood trauma and the long-term effects of childhood trauma.
The idea of requesting a resentencing is not entirely unheard of. It does happen. Usually it's based upon a change in the law. If there's been a change in the sentencing guidelines, perhaps someone can ask and petition the court to have them resentenced. But this idea of resentencing someone based almost purely on a publicity push, a social media groundswell of people saying, hey, they need another look. You mentioned at the top of the story, the Netflix series, several documentaries have been done about this. And now this new habeas petition, I think it's kind of a perfect storm of efforts pushing towards this, but it's not entirely based on any kind of change in the law, just a change in the way they're viewing this case now 30 years later.
Well, and it is important to also say that while all of that is true, the Menendez brothers, the whole trial, it still rings for people. They remember it. Mm-hmm. But it is also important to note that, as you said, resentencing guidelines are a thing in California. And there are any number of people who might have been involved in a crime. They were involved in a crime where a murder was committed. They were found guilty of murder, but then those resentencing guidelines found them only guilty of, let's say, armed robbery. They weren't the person that pulled the trigger. Those people, too, have been released. So we are caught up in, and rightfully so, I think, the Menendez element of it. But this is going on across the state, isn't it?
Oh, absolutely. No, in every court across the state, they are hearing these types of hearings. My point is that they're usually hearing them based upon some sort of statute that you can point towards and say, listen, now under the current law, this person would not have been sentenced that way had this case been tried now. With these sentencing guidelines that we have now in front of us, and we're asking, please, in the pursuit of justice, to resentence this person. Here, there really hasn't been a change. It's just, hey, let's look at this case through the lens of 2024. Let's look at back at a crime that was committed in 1989 in a different way. And in reevaluating that, do you think a more appropriate charge may have been manslaughter?
What kind of timeline can we expect once the judge gets this recommendation, if he does?
That's a great question, because this is a little unheard of. But I imagine if Gascón makes a recommendation today, they're going to have to file papers with the court. It's going to have to be put on the court's calendar. It's going to go back to that same trial court in which the trial was originally heard. The judge is no longer there. He's long since retired. They will have a hearing, and then a decision will be made by that judge. So it's not going to be overnight. We're not going to see, footage of them walking out of prison anytime soon, but it could be a matter of weeks. It could be something that takes place before the end of the year.
And one of the things, too, is, as you're mentioning, it's not before a judge yet. So the wheels of justice can move very slowly. But am I not mistaken in one of the reasons we're so close to this happening is because at this point, Gascón is saying their behavior in prison has been such, it's been exemplary. They haven't even presented any new evidence, so to speak, that would say they've missentenced them. Right now, it's almost, we're looking at if they had manslaughter and they served this many years, they've done this thing. Am I right there? That much of what has been done right now is behavior in prison justifies these new actions?
You're right. That is a large part of the argument that their defense team is making, is that, listen, in the meantime, in this 30-some-odd years since they've been in prison, they've been exemplary prisoners and demonstrated it in many significant ways. But they're also saying the reason why they filed that habeas, which is actually separate and apart from what we're dealing with today, but that habeas is where they turned over this new evidence, which was a letter allegedly written by Erik to one of his cousins that was 8 months before the murders, that talked about this abuse, and also a declaration from one of the members of the boy band Menudo, who talked about also being abused at the hands of Jose Menendez. And their request was based upon that evidence that wasn't available at the time of their trial. There may have been a different result. Now, what Gascón is saying is, I'm going to independently take a look at that evidence, and if I agree with it, then I'm going to request that they simply be resentenced and put this in front of a judge and say, we no longer feel that first-degree murder was the appropriate sentence or conviction at the time based on this new evidence. We're asking for them to be resentenced on manslaughter.
The interesting thing about what you're saying right there is that I would think that most prosecutors would say, no. I need to challenge that's coming from the defense, because you could argue a letter written in advance because we were talking about first-degree murder at the time, it could show potential cover for premeditation. But in this case, the DA is not taking the adversarial side of that letter. The DA is taking almost the side of the defense, saying, if this is what's happening. Again, so much of this is in the front. Do you see what I'm saying with this? A DA that's got a different mindset could look at that letter also differently than the current DA is looking at it.
And a different DA could take a look at that letter and say, in spite of this letter and in spite of that declaration, the jury has spoken, and we should respect a conviction, a verdict handed down by a jury, and that shouldn't be overturned just because of this new evidence. And I will say too that I happen to know that even within that office, there's a lot of conflict. They're not entirely all in agreement with, if we're assuming he's going to make that decision, not all of the line deputies are in agreement that this is the correct decision. There are many people who were still in the office that were involved in that case, working in the office during the time that case was tried, who feel very strongly that the correct verdict was acquired back in the 90s.
How much influence does the family have? We heard recently, as early as last week, about from the sister of Kitty Menendez, the grandmother of Erik and Lyle.
I think that's who we're looking at.
I think we're looking
here,
at the
yes,
grandmother
yeah.
right there. She was just being comforted just moments ago. How much of that public opinion and the family themselves saying that they believe these boys have had enough punishment?
I think that's really helpful for the defense's cause, obviously. To the sense that if they were opposed, if they were coming out strongly and saying, we don't even want to entertain this is a travesty and a miscarriage of justice, I think it would be very hard, both from a legal and certainly from a political standpoint, for the DA to come out against them. But they are all in favor, or not all, but a large portion of them, as we saw in that press conference, are very much in favor of this push towards resentencing. So I think that provides some, at least, cover from the perspective of the victims are also on board with this.
Well, we are looking at Mark Garagos now talking to the family, and we are continuing to wait a scheduled 1:30 press conference from George Gascón to announce what his intent is on this next step as it relates to the Menendez brothers. And again, Mark Garagos and Mr. Gascón have both said that they have been looking at this for almost a year and a half. Garagos had explained that they were aggressively looking at this for a year and a half. And Joshua, you mentioned that there is debate as to the path forward. I think that's just a common feeling for so many people. I don't know of anyone that I've spoken to on this who lived the trial, who remembers the trial, that's really adamant that they are certain as to what should happen with this.
I know, I think you're right. I think that is part of the reason why it is a case that continues to fascinate us decades later, is that you can still have some pretty strong debate about it. You know, I certainly understand their position as far as being victims of abuse and, you know, feeling like they had no other alternative. And then you get people who say things like, but yes, what about the mother? You know, if they were victims at the hands of their father, and that's horrible, and perhaps they acted in an unreasonable way under the circumstances, was the mother an innocent bystander? Why did she deserve to lose her life as well? I mean, it's hard. It's easy to forget too, I think, what a violent and horrible crime this was. They were shotgunned to death to the point that they had to reload to finish the job. So we're talking about a very, very serious murder. It was first degree. It was special circumstances, meaning it was eligible for the death penalty at the time. And now here we are 30 years later talking about perhaps a manslaughter and then being released from prison.
And that's one of the things that I keep coming back to, is it's almost a retrial of something that we're not really having a trial. We're just debating this resentencing and the change of culture, which takes me to the resentencing units that actually began in 2021 in the DA's office, when they really began to look at some 20,000 or so cases, maybe even more, where we're changing the sentencing guidelines. Is this case, does it fall into the resentencing unit? I mean, they're currently reviewing some 681 cases so far. They've released or resentenced some 300 people. So is this in that, or is this in and of itself a separate situation here?
This is really an entirely unique situation. There is a resentencing unit. There has always been a unit that takes a look at old convictions to see whether or not there was any kind of miscarriage of justice. Gascón and his administration has heavily pushed that agenda, the idea of reducing prison populations by looking at resentencing. He's received some criticism for that. But this is really a unique situation because this isn't, like I said, based upon some sort of change in the law or statute. It's merely based upon a reflection, taking a look back in hindsight at what occurred 30 years ago. Do we think we should look at this a little bit differently? They're going to point to some of that new evidence, but I really don't feel that that evidence is the driving force behind this. I really feel it's a change in the way that people view this case, along with just kind of this cultural push with, the documentaries and the Netflix series and everything else that seems to be really putting this case back in the cultural zeitgeist.
Well, it's interesting because ABC did that special, the Menendez brothers, monsters or victims, and they were talking about how they interviewed the jury when they came out and said none of them could believe that a man was capable of molestation, of molesting their own son. And since then, obviously, with the priest abuse cases and many other things coming out, public opinion certainly has changed, and also that boys were capable of being molested. But we used to not think that. So public opinion really has changed culturally as well. Do you think that has a big impact on this particular case?
No, you make an excellent point. I mean, it's easy to forget that they were mocked in the media back then. Their claims of abuse were ridiculed. I mean, on late night talk shows would make jokes about it. Saturday Night Live did skits about it, mocking them, telling these incredibly traumatic stories and crying in court. Regardless of how you feel about whether or not the verdict should stand, I think that we can certainly say that had that trial taken place today, you would not see that kind of response from popular culture in the way that you saw back then.
Well, and as we look at family members here, that is one of the most striking things is what you just said, and whether you can or can't believe them. The reaction of how we handled it back when it was going on and how we are looking at it now. When you have direct family members of the victim, I mean, we are talking about Kitty's sister because, Joshua, you pointed out, what about the mother? If the father was this monster, what about the mother? Why her? When the sister is one of those who are in the camp of the Menendez brothers, that is remarkable to me as not just a journalist, but as a person.
Right.
When Kitty's sister is involved in this effort, that speaks volumes, doesn't it? Even in the justice system, which is supposed to be, almost antiseptic, where you're just looking at the facts presented, that's pretty powerful.
Oh, it's incredibly powerful. Part of what the DA's office is supposed to do is pursue the interests of victims and protect victims. Well, here you have the victim saying, hey, we think they did something wrong, but we've also think that they've paid their price for it, that there was extenuating and mitigating circumstances, and that we should take another look at this, and that they've done their time. Whether you agree with that or not, it's hard to argue with the impact hearing from the victims, and not just a few, but a lot of them came forward to say that they all share in this view that they should be released.
Well, Joshua Ritter, again, is joining us as we await L.A. District Attorney George Gascón's decision. And again, we thought this was going to start right at 1:30. And for some reason, Joshua, could there be something going on right now? We've seen Mark Garagos there in the screen come and go. He continues to talk to Kitty's sister there, the family, who seems to be comforting. We feel like, I think you nailed it at the very beginning. Why would we be having another press conference if we didn't feel like to have a press conference now to say I'm not doing anything?
Exactly.
Strikes me as very strange. But why the delay, do you think? What legally? I don't want to try to get into the minds of anyone else. But could there be legal issues here that would cause a delay in this announcement here on a Thursday afternoon?
I don't know about legal issues, but I mean, to our point too, the fact that you have Garagos sitting there with the family members in the front row seats, I can't imagine they're putting this thing all together, like you said, to disappoint all of them with an announcement that isn't favorable to their cause. As far as why we're sitting here delayed, I think that's anyone's guess, but I don't think that it's because of some sort of last minute, petition by some other interested party to somehow delay this, because as of this point, nothing has been filed. So I imagine what we're going to hear today is his intention to actually file something. As far as I know, there has not been a legal document entered into the court system by the Gascón administration in regards to this case just yet.
And what we understand is DA Gascón really wants to push this through. If he goes through with it, he's talking about a release as early as before Thanksgiving.
How could that happen legally? I mean, could it happen legally?
I mean, there's no kind of statutorial guidelines as far as how long or how quickly it could happen. It really depends on getting the case in front of a court, which is, sometimes as simple as calling the court and asking for when their next available date that they have to have this heard and filing their motions. It would be interesting to see if there's some sort of amicus filed by another party in opposition to that. Not unheard of, but eventually this will end up in front of a court. There's no reason to delay it. That judge may want to review the law to make sure that they're not just acting out of, emotion based upon the pursuit by both the DA's office and the defense, that there is some sort of legal precedent and ability that they have to do this. But, short of all of that, it's just a matter of a judge making an order. So it could move pretty rapidly.
And to that end,
November, Thanksgiving's not outside of the realm of possible.
Okay. To that end, I have spoken with and done a story with a person who was resentenced, had been life without parole, and within weeks went from feeling like he was in prison for the rest of his life to living on a college campus, finishing his degree. It was that fast. Is that what we're looking at here potentially? Once the judge makes a decision, you're out? Or will there be some paperwork, some mechanisms that have to take place from being in prison, thinking I'm there forever, to out? I mean, it's happened already. Is that something that could happen here?
I mean, you make the point that the judicial system seems to move at a glacial pace, but putting aside any sort of, unforeseen legal interference, it could move that quickly. I mean, it is a matter of just a judge making an order. If this sits in front of a judge and the judge decides, I'm going to go ahead and resentence them, that can take place that afternoon. And once that order is entered, they will receive credit for the time that they've already served, which is more than enough to have satisfied a manslaughter conviction in this case. And then at that point, the state of California has no ability to continue to hold them any longer. A judge will make an order, and it could be, I don't know if there's some sort of health standards and safety checks that have to be done inside of the prison system, but there isn't really any reason to delay this. It could move very quickly once that order is made by the judge.
We should note that not all of the family, the Menendez brothers, do want them out early.
Exactly.
I believe it was Kitty's brother also. He was opposed to it. So how much say and how will he have to weigh which family members and how many people want him out, and the family members versus the ones that want him to stay? Is it just
the California has a Victims' Bill of Rights, Marcy's Law, that that any victim family member can be heard. So there could be an opportunity for those family members who are opposed to hire their own counsel or independently file something to request to be heard by the court. So there could be a hearing where we could hear opposition to all of this, and a judge is going to have to weigh that. So it's not that this will be done without their voices being heard or considered. It's just that as far as a legal mechanism to delay this, there's nothing that's coming to my mind as I sit here.
Well, I think that's a very valid point, because we are right now hearing the people who are most interested in this particular outcome as we potentially think it's going to go. But 100% right. There are people who don't believe them,
right,
who thought that this was a completely different thing and are more than satisfied. But again, it's a very interesting thing in that, okay, so how would that side of the argument be heard legally? If Gascón, is that going to be at the hearing? Whatever hearing might come forward, they might say, hey, I want to speak?
Yeah, absolutely. And then they will be afforded that opportunity, absolutely, to be heard, as victims are afforded that opportunity at any hearing in the criminal justice system. I think a point should be made, too, that, the judicial system and judges, they favor upholding verdicts. I mean, we want there to be finality in our judicial system. We want a trial to take place, 12 people to decide, a verdict to be handed down, and for that to be the end of the story. And in rare cases where there was some sort of miscarriage or there's appealable issues, you can understand why that might be overturned. But for the most part, just simply 30 years later saying we don't like this anymore, we've changed our minds, or the ways that we view this, is usually not the standard to request something like this. So there is not entirely a precedent for doing this, and there is a favor towards upholding verdicts. So I'm not saying this is an easily done thing, but again, if you have both the DA's office and the defense and victims' family members all favoring this, you could see how it could easily go their way.
Well, Joshua, I'm getting word that Kitty's brother actually might be filing an amicus brief. So if he does that, how does that play into what we're doing now?
That would be heard during that same, like I said, it's going to go in front of a judge.
So that's basically a formality that would have already been done.
That may cause a little bit of delay, in that the judge may want to have, afford people opportunity to be heard in argument. It may cause the judge to do a little bit more research. But again, these types of hearings are heard all the time, where there are opposing sides to all of this, and decisions are made every single day. So I'm not surprised to hear that something like that may occur, but I don't think we're talking about a delay, pushing us back several months. It may keep us on the same timeline.
Could it possibly delay Gascón from making this announcement today, or is that just behind the scenes?
I imagine that those folks who are opposed to this have been aware that this was in the works for a while, and they've probably made those objections, if not formally, at least informally, to him through their representatives. I'm guessing that if he's decided to call this press conference, he's heard that opposition and weighed his decision before going ahead and taking this podium.
Well, it does go to what Ellen said. When I find it fascinating that the sister is in support of the niece and the nephews, that there is another side to this. And in families, we all can have disagreements. And so in this particular family, and you can imagine with something of this magnitude, they're all not going to agree to the same thing. And I would think that that's another reason why it took Gascón a year and a half of engagement with Garagos and the Menendez brothers to come to whatever decision we're awaiting.
Yeah, no, absolutely. And I should say, too, for people to understand, this is really the last of the last-ditch efforts that they have at all of this, because they've appealed this case before and been denied. They've exhausted all of their appeals. One of the hurdles you have to satisfy in order to even file a habeas is to show that you've exhausted all other avenues of appeal. So when they filed that habeas last year, it was really their last-ditch opportunity. Now, this is something kind of a unique add-on, but being denied this here, if that's what Gascón announces, I really do feel that is the end of the road for these two men.
Wow. Well, can you paint a picture for us? Would it be like any type of resentencing phase of a trial? They would have impact statements from all those involved that are still alive?
I think that would be wrapped up in the entire hearing as part of the victims being heard on even the decision to do this. You're right, a resentencing hearing would actually take place as well. But when we're talking about resentencing someone from first-degree murder to manslaughter, we already kind of know what those guidelines are. And even at the far end of the guidelines for manslaughter, I think they've already served enough time. So it's not a matter of a judge even picking a number within that sentencing range on the manslaughter. They would most likely have satisfied all of this as far as the time that they've already served. And it would be just a matter of, do they get sentenced to that? And when does he actually order their release?
Joshua, if I could, and I'm just getting this, so I'm just going to read it for us. It is a statement from the victim's rights attorney who is working with Milton Anderson. He is the 90-year-old who has what they call an endured unimaginable loss of his sister, Kitty Menendez. So this is a statement, and he's saying in this statement, despite numerous requests, Gascón has refused to inform Mr. Anderson of any decisions before holding press conferences. Mr. Anderson has been left in the dark, forced to learn crucial updates about his sister's case through the media rather than being treated with the dignity and respect he deserves. Now, I'm just reading this out. We have a media contact, which I will not name, but that is apparently coming from the brother of Kitty Menendez, who is claiming in this statement they're dismissing the crucial evidence ahead of the election. And the thing, Joshua, that strikes me on that is apparently Mr. Anderson is deeply upset that he's, what they're saying, been left in the dark about these decisions. Meantime, you have Mark Garagos and Joanne Anderson there, the sister, who seemed to be intimately involved in the process. So there is some back and forth here that doesn't seem to be what you would like to see with something like this, where everybody is talking and we're trying to come to the right decision. If Mr. Anderson is telling us the full story, he's being left out of this.
No, you're absolutely right. If that is true, that is really unfortunate, because that really is not the way that the DA should be handling this type of a case of this magnitude, this much media attention, this degree of sensitivity. The DA's office is used to making incredibly difficult decisions that affect a lot of people's lives. And many times those decisions are not easy, and many times those decisions do disappoint people. But part of doing the job is informing those people and letting them know that in spite of their requests, the DA's office feels it's in the interest of justice to pursue a different path. And you would have hoped that certainly in a case like this, that would have occurred. So if that is true, that's really unfortunate. Now, how will that affect things moving forward? Probably not a lot as far as what Gascón is going to decide today, but when it does get in front of a judge, they will get an opportunity. They have California gives them a legal opportunity to be heard and considered by the judge before the judge, who actually will be the ultimate decision maker on this whole thing.
Well, we have just taken a look at the amicus brief. It was signed by Kathy Cady. She's the victim's rights attorney, retired deputy district attorney. Not being a legal expert, I don't even really know, to be honest with you, Joshua, what to look for, other than this is an application to file an amicus brief, habeas claim. So much of what you're saying, and then it's a long, lengthy brief here that they are filing, and it does look as if it was a confirmed copy October 23rd. So today's date is October 24th. So if this was filed yesterday, that really wouldn't matter with Gascón's decision today, or could it potentially make him be rethinking what he's doing?
I guess my point is that his decision today is merely him declaring his intent on what he intends to argue in court. His decision today really doesn't have an effect on the Menendez brothers' future. I mean, it does in the sense that it will obviously be viewed as a win for them if he supports their release, but he is not the final decision maker. So the DA taking a position on this that's adverse to one of the family members who's filed an intent to file an amicus, I think that what that means for us is that it's not entirely going to be smooth sailing from here on out, but the same procedure will take place. They will file a request of the court for a resentencing hearing. A resentencing hearing will be calendared with the trial court. A date will be set for the arguments on that, and eventually a judge is going to have to make a decision. And all of those steps could happen with, alacrity within the next, month or two.
So this sounds more like a formality, not any legal binding thing that an announcement would be made today. It's just his intent to file or to recommend to the judge.
It doesn't prevent him from making his announcement today.
Which I just look at the room. I'm just trying to read and see if we see anything from this room that might indicate that Gascón is coming out anytime soon, and we continue to see Garagos leave and come back. We have a new party that has come in and sat down next to the sister. Joshua, I keep coming back to what you said earlier, that the court likes to respect the decision of a jury. And when I come to this amicus brief filed by Mr. Anderson, you start to wonder, okay, in front of a judge, we now, earlier we said when the prosecutor and when the defense come before the judge and ask for the same thing, well, the judge is probably going to go with that. But we don't have that if this amicus brief is happening. And so to that end, for people wondering what might happen, it is important to note what you just said. The judge is going to probably lean in the direction of siding with what the jury said. And when you have these parties now arguing this case in front of this judge at a date in the near future, the smooth sailing comment, I think, is right on the money. Many people just think this is going to happen just because it's being announced maybe today. That doesn't appear to be the case. It does seem to be there might be a bit of a battle here.
You're absolutely right. The overturning a verdict is no small task at all. It's no small ask of a court at all. Judges are very concerned with something called precedent. They want to make sure that what they're doing is not somehow setting a precedent, because you can think if this was as easy as it was, just having a documentary made, getting some people together, appealing to everyone's emotions and feelings of nostalgia about a case that took place 30 years ago, and then just saying we don't really have a legal basis, but it's more of an emotional plea to have our verdict overturned, the courts would be flooded with these types of requests. So certainly the judge is going to be very concerned with what kind of a precedent is being set if they go ahead and decide to make this decision. Now, obviously takes some of the pressure off of the judge when the DA's office is pursuing it and the DA's office is saying, listen, this is based upon new evidence. With this new evidence, we've taken a different look. Had we had this evidence back at the time, we may not have filed the case the way that we filed it. It's not a lost argument, but it's still, to your point, no small undertaking to say we want to overturn a jury verdict. It's one of the things that we need to respect more than anything in our criminal justice system, is that a jury's verdict should be final.
Come to this, and is there any precedent with some type of case like this?
Well, when you're talking about a case where and I'm not trying to oversimplify it, but when you're talking about a case where the lion's share of their plea has to do with, we think it's fair, essentially a plea to emotion and fairness and changed cultural views, I can't think of something like that in recent memory. The idea that, hey, laws have changed. If they were making a plea that this case would not have been filed that way under our current laws nowadays, that would be a very different argument. But their argument is really, they've been model prisoners. They did suffer abuse. We look at abuse differently today. Again, I'm not trying to oversimplify or belittle their arguments, but they are saying there is other evidence. But I think really their plea is that we have changed a lot, and certainly Gascón highlighted that the view towards abuse, victims of abuse, how we view people who react to that type of abuse, and certainly males being the victims of abuse has changed a lot, that we may have viewed this case differently today. Yeah,
we certainly have learned so much about the effects of trauma and long-term effects, and perhaps what would make somebody act a certain way after the trauma.
1,000%. And by the way, when we talk about this with a potential new DA, however the election results, that Nathan Hogman has not made a public announcement about what he wants to do here if he were in office. But a question to you, Joshua, from a colleague. If there is an election and this decision has not been made, but it's made somewhere in the interim before a new DA takes over, What is the logistical element of that? Is it much like a presidential election where he's in office until a new person is inaugurated? So many things can happen in the interim. What happens in that circumstance if a new DA comes on and they do have a different opinion? And again, Nathan Hochman has not weighed in on this, so I'm not trying to put words in his mouth. How does that go?
I think the legal term for it would be a mess, because it would be something sitting in his lap. Now, if the DA's office actually files a document, makes an argument, submits and files that to the court, the hearing is heard under a new administration who takes an opposite view to that. Yeah, that would be a problem. And because that DA has his own edict, he has his own feelings. He's been voted in and he has different views on how this case should be handled. I see that Gascon's walked in now.
Yes.
Just
Long
shook
story
hands with the
short,
sister.
I think it could be a mess.
Okay. Thank you, Joshua.
You have been wonderful, Joshua. Thank you so much.
Absolutely.
And as we mentioned, and as Joshua noticed, George Gascón is taking to the lectern and to make the announcement we have long been waiting for. So let's listen in.
Good afternoon, everyone. And before I begin speaking, I want to also introduce some other people that are here with me, and I hope I'm pronouncing the names right because I've seen handwritten part of it. But I have Ana Maria Barat, Jose Menendez, Jose Menendez and niece Karen Vandermolen, and Kitty's niece. They're all here with us. Also with us here is Brock Lunsford. He's the Assistant Head Deputy for the Post-Litigation Conviction Unit, and Nancy Cervier, who is the Deputy District Attorney in charge of the resentencing unit. Let me begin by telling you that this is a case where we've had many people in this office spend a great deal of time reviewing the case. I have to tell you unequivocally that we don't have a universal agreement. There are people in the office that strongly believe that the Menendez brothers should stay in prison the rest of their life, and they do not believe that they were molested. And there are people in the office that strongly believe that they should be released immediately and that they were in fact molested. I have to tell you that after a very careful review of all the arguments that were made for people on both sides of this equation, I came to a place where I believe that under the law, resentencing is appropriate, and I am going to recommend that to a court tomorrow. What that means in this particular case is that we're going to recommend to the court that the life without the possibility of parole be removed and that they would be sentenced for murder, which, because there are two murders involved, that would be 50 years to life. However, because of their age, under the law, since they were under 26 years of age at the time that these crimes occurred, they will be eligible for parole immediately. The teams that have worked on this, on the resentencing side of it, have spent literally probably hundreds of hours by now looking at this case. These cases were originally presented on the habeas side of it, which I'll explain in a moment what that is, last year, and then the request for a prosecutor-initiated resentencing occurred earlier this year. And there have been people in this office working in these cases from the very beginning, as well as many other cases that we have. The reason why I'm here today and why I came in front of all of you about 10 days ago is because there was a more recent documentary about the case that again brought a tremendous amount of public attention. And we know there have been other documentaries, so this is not the first, this is a more recent one. And frankly, our office got flooded with requests for information. And even though this case was already scheduled to be heard in late November, I decided to move this forward because, quite frankly, we did not have enough resources to handle all the requests, and one of the things that I thrive to do in this office is to be very transparent in everything that we do. In this case, we review the prison files. And you have to understand that the way the process works, when you're talking about a resentencing under the law, it really focuses not necessarily on what the original crimes were, but it focuses on, has the person been rehabilitated, number one, and number two, can they be released safely into the community? Under that rubric, since I've been in office, we have resentenced over 300 people, including 28 for murder. Only 4 have reoffended. If that was a regular recidivism rate in this country, we would be the safest nation in the world, but we know that it's not. In fact, somewhere between 40 and 50% of the people that go to prison reoffend and get rearrested. And that's why we have so many problems. However, when you look at the case of the Menendez brothers, you see 2 very young people. One was 19 and the other one was 21 when they committed this horrible acts. And I want to underline, they were horrible acts. There is no excuse for murder. And I will never imply that what we're doing here is to excuse that behavior. Because even if you get abused, the right path is to call the police, seek help. But I understand also how sometimes people get desperate. We often see women, for instance, that have been battered for years, and sometimes they will murder their abuser out of desperation. And I do believe that the brothers were subjected to a tremendous amount of dysfunction in the home and molestation. But they went to prison for life without the possibility of parole, which meant that certainly under the law at that time, they had no hopes of ever getting out. They could have done what many other people do, which is basically said, you know what, I'm here for the rest of my life, so I'm going to do whatever. I'm going to misbehave, I'm going to join gangs, I'm going to live the life of the prison. But they never did that. To the contrary, even though they didn't think that they would ever be let free, they engaged in a different journey. A journey of redemption and a journey of rehabilitation. And often the people that begin their journey of rehabilitation and redemption in prison is often very internal. And what they do, and one of our lawyers pointed out this today, is usually the path is people try to further their education, do things for self-improvement, which the brothers have done, by the way. But it's more unique or less usual, I guess, when people not only do that, but they also begin to engage in ways to make life for others better. And in this case, the brothers have been doing so for a very long time, creating groups to deal with how to address untreated trauma, creating groups to deal with other inmates that have physical disabilities and may be treated differently. Even in one case, Lyle negotiating for other inmates as to the conditions that they live under during prison. And all this was done by 2 young people, now they're not as young, that had no hopes of ever getting out of prison. They have been in prison for nearly 35 years. I believe that they have paid their debt to society, and the system provides a vehicle for their case to be reviewed by a parole board, and if the parole concurs with my assessment, and it will be their decision, they will be released accordingly. I must underline, however, this case will be filed in court tomorrow. The final decision will be made by the judge. Court has to agree with my conclusion that they deserve to be resentenced. It is very possible that there may be members of this office that will be present in court opposing the resentencing. And they have a right to do so. And we encourage those that disagree with us to speak, and the court is the appropriate place to do it. We certainly feel we're very sure not only that the brothers have rehabilitated and that they will be safe to be reintegrated in our society, but that they have paid their dues, not only for the crimes that they committed, but because of all the other things they have done to improve the life of so many others. So, again, we will be filing for resentencing tomorrow. We're seeking that they would be sentenced to life with the possibility of parole, as opposed to life without the possibility of parole, which is they currently have. That means that they would have 50 years to life because there were 2 murders. But because of the age upon which they were convicted, under 26, under current law, that means they're eligible for youthful parole. I think there is also important to have some introspection today, because I think that often, for cultural reasons, we don't believe victims of sexual assault, whether they're women or whether they're men. We saw in our first trial, which, by the way, they were tried twice. The first trial hung, meaning the jury could not come to a conclusion, and in fact, about half of the jury wanted to convict them of manslaughter, which, if that were have been the case, they would have been off prison a long time ago. And then there was a second trial, and then they were convicted of murder with special circumstances, which led to the life without the possibility of parole. But it's salient to understand that our own implicit and sometimes explicit bias around sexual abuse and sexual assault often leads us to severe injustices in our community. And I want to speak to those that are victims of sexual assault now, whether you're a man or a woman. Know that we're here for you. If you're a victim of sexual assault in this community, and by that we're talking about LA County, not just LA City, you can come for help. Whether you're prepared to prosecute or not, we will be here for you. We have services for you. And if you're prepared to move forward with the prosecution, we will evaluate it as we do any other case. And if we believe that the evidence is there to present a credible case in front of a jury that can be proven beyond a reasonable doubt, we will proceed accordingly. You do not have to suffer alone. You don't have to keep it to yourself. And help is here unconditionally. I'm going to say a few words in Spanish because I know there's tremendous amount of interest from the Spanish media, and I know that there are going to be other speakers today, and then we're going to open it up for questions. Primero que nada, quiero dar las gracias a todos por estar aquí hoy. Estamos hablando del caso de los hermanos Menéndez. Este fue un caso donde 2 hermanos, uno de 19 y uno de 21 años, asesinaron a sus padres más de 3 décadas atrás. Estos muchachos fueron condenados por asesinato y llevan en la prisión alrededor de 35 años. Este fue un caso que tuvo mucha atención pública cuando sucedió y indudablemente tiene mucha atención pública hoy cuando vemos esta habitación como está llena. La razón por la que nosotros estamos buscando que la Corte reevalúe la sentencia original es la siguiente. Bajo la ley de California, cuando una persona es acusada de un crimen, ese crimen puede ser reevaluado si la persona lleva muchos años en la cárcel o la prisión y enseña que se ha rehabilitado y que puede ser reintegrado en la comunidad sin causar peligro para el resto de nosotros. En el caso de los hermanos Menéndez, nosotros hemos revisado el caso y creemos, número uno, que se han rehabilitado y número dos, que pueden ser reintegrados en la comunidad sin causar peligro para el resto de nosotros. Es importante notar que este es un caso de dos muchachos que tenían 19 y 21 años, que probablemente fueron no solamente acosados por su familia, pero posiblemente también fueron molestados sexualmente. Aunque no hay excusa ninguna para los crímenes que ellos cometieron, reconocemos también que habían ciertas condiciones que pueden haber creado esta situación. Desde que están en la prisión, ellos han demostrado con sus acciones y sus palabras que iban a hacer todo lo que era posible para rehabilitarse. No solamente ellos hicieron cosas para mejorar su vida personalmente, pero también tomaron parte en muchos programas y crearon programas para ayudar a otros prisioneros. Hicieron todo esto durante un tiempo donde ellos no creían que iban a salir de la cárcel por el resto de su vida, porque su sentencia era de vida sin la posibilidad de salir de la cárcel. Lo que estamos haciendo hoy bajo la ley de California, vamos a hacer una petición a la Corte a que reevalúe esa sentencia y que lo vuelva a sentenciar por asesinato, pero con la posibilidad de salir con libertad condicional. En el caso de ellos, porque son dos asesinatos, serían 50 años o por vida, pero con la posibilidad de ser prohibido la oportunidad de salir con condiciones. Bajo la ley, cuando el crimen se cometió y la persona tenía menos de 26 años cuando lo cometió, esa persona puede ser evaluada inmediatamente para que su sentencia sea revisada y que se le pueda dar otra sentencia. Bajo las condiciones de cómo ellos se han portado en la prisión y la evidencia de que están rehabilitados y de que pueden ser reintegrados en nuestra comunidad, es muy posible que ellos sean permitidos salir a la calle de nuevo, pero esa decisión estará con el sistema de prisiones y no con nuestra oficina. Legalmente, lo que nosotros vamos a hacer mañana es presentar una petición a la Corte. La Corte es la que toma la última decisión y la Corte puede acordar con nosotros o no, pero creemos que bajo la ley la petición que estamos haciendo está bien fundada y creo que esta petición espero que sea permitida. Ahora voy a pasar para que otras personas hablen y después podemos tomar sus preguntas. Ana María, you're going to talk next? Okay.
Good afternoon. My name is Ana Maria Baralt, and I'm the niece of Jose Menendez. Erik and Menendez are my cousins. I would also like to acknowledge the other family members here, some standing, some seated. Joan Vandermolen is here, Kitty's sister, as well as Diane Vandermolen Hernandez, Kitty's niece. Thank you for joining me, everyone. Today is a day filled with hope for our family. We are here because District Attorney Gascón has taken a brave and necessary step forward by recommending a resentencing for Lyle and Erik. The DA's decision reflects the truth that is hidden for so long, and I am grateful for his leadership in making this choice. We stand united in our hope and gratitude. Together, we can make sure that Erik and Lyle receive the justice they deserve and finally come home. Thank you to District Attorney George Gascón for his courage and leadership. This step gives us all hope that the truth will finally be heard and that Lyle and Erik can begin to heal from the trauma of their past. Thank you so much for your time.
Thank you, Ana Maria.
Yeah.
I believe Jose Menendez is going to say a few words.
This is the niece of Kitty
Oh, you're gonna
Menendez,
say, I'm sorry.
Joan Vandermolen.
Yeah.
Hi, thank you for coming. We are here today because District Attorney Gascón has taken a brave and compassionate step forward by recommending resentencing for my cousins, Erik and Lyle. And we wish to offer our deepest gratitude to DA Gascón. This decision is not just a legal matter. It is a recognition of the abuse my cousins endured, and we are grateful for the DA's leadership in putting justice over politics. We know this wasn't an easy decision, but is the right one. This is about truth, justice, and healing. It is time for Lyle and Erik to come home. And I ask all of you to join us in this fight for justice. We stand united in our hope and in our gratitude. Together we can make sure that Erik and Lyle receive the justice they deserve and finally come home. Thank you again to District Attorney George Gascón for his courage and leadership. This step gives us all hope that truth will finally be heard and Erik and Lyle can begin to heal from the horrors of their past. We hope this will also shed light and increase awareness and help others who have been victimized by sexual violence. Thank you all so much for being here today. We are grateful for everyone's support.
Is there anyone else speaking?
No, that's it.
Okay. Okay, and I apologize. I'm reading notes here and I'm trying to understand all the notes. Yes, ma'am.
Can you explain, so you go tomorrow, you file a case for resentencing, then what happens after? Are the brothers gonna be there tomorrow, and when is the role of the parole board going to come in?
Right, and you know what? I'm going to actually have the people that are handling the case walk you through all of it. The brothers will not be there tomorrow. The role of parole board comes later, but Nancy, why don't you walk everybody through?
Okay.
Yeah.
So what we'll do is we'll file our...
Say your name, ma'am, your name and your title.
My name is Nancy Thaberge. I'm the deputy in charge of the resentencing unit. This is Brock Lunsford, assistant head deputy of the post-conviction litigation division. So what will happen is tomorrow we will file the actual petition requesting resentencing with the legal arguments and accompanying exhibits as to why we think it's appropriate. It's just a filing. No one's going to physically be in the courtroom. From there, we'll also serve the defense with our motion and our paperwork so that they'll have their copies. And from there, we will coordinate with the defense to set up a court date with the court so that the petition can be heard. Now, whether or not that's a setting or a hearing will be decided between us and the defense and the court once everybody gets an idea of what we've filed. Then from there at the hearing, the defense can either decide to have the defendants, the Menendez brothers, physically brought into court. They can ask that the individuals appear by video or audio WebEx, a kind of a Zoom participation, which we all kind of adapted to because of COVID. And then from there, we will do the hearing and submit all the written and legal and oral arguments and any evidence that needs to be admitted at the time, and then the court will rule at that point. But we don't have that court date yet because we're just starting the process tomorrow. But it's our intention to have that go forward before the habeas, because if the judge grants it, that may impact the defense's decision to proceed on the habeas. So we're gonna try it just as a matter of economy of time to stack it one before the other.
Now, have the brothers found out about this in real time, or were they told about this beforehand, or what was their reaction?
No, this
No,
was...
this is actually the family was only invited to come. They were not aware what the final decision was until a few minutes ago. The brothers may be actually seeing you guys on TV or social media, but no one knew other than a very small number of people in this office. And by the way, I should tell you that actually the final decision was just made about an hour ago. Right, then it goes back to the prison system, and then the parole system takes over that. That's correct.
Would there be a parole or probationary period? Would they have to live in a halfway house, or simply be released
You know, those are really completely entirely up to the parole board. Please, we'll try.
What was the factor that made the final decision? You said the final decision was just made. Was it the letter? Was it the Menudo confession? What was it that put you over the top to make?
No, what it was is I was evaluating the arguments that were being made within my office, both pro and against the release.
DA, can I ask you?
Hold on, I had it.
A lot of phone calls from
Yeah.
people that.
I'm, you know, you have made resentencing a cornerstone of your tenure as district attorney here in Los Angeles. There are some people who have accused you of using this very, very highly publicized, clearly case to use it for politics, given how close we are to the election. What's your response to people who have been making that claim?
There's nothing political about this. We have resentenced over 300 people, including 28 for murder, and we will continue to resentence people in the future. And that's all I can tell you.
But DA, question. But
Yes,
how
sir.
is your bid for
Excuse me,
re-election
please.
impacting your decision?
You're interrupting.
Everyone's interrupted. I'm just
No.
wondering how your bid for re-election.
Yes, please. Yes.
Could the brothers be home by Thanksgiving?
I don't know the answer to that.
Why did you decide not to go with the reduced voluntary manslaughter?
That was part of the process that I was still going through up until a couple of hours ago. I don't believe that a manslaughter would have been the appropriate charge given the premeditation that was involved in the murders. I believe that these were clearly murders that were premeditated. Now, the motivation, that's where, differences of opinion come up, but I didn't think it would be appropriate to go all the way down to manslaughter.
DA,
Yes,
has
ma'am.
your bid for re-election impacted
Would you
your
please
decision?
stop? I am not going to talk about re-election, okay?
Okay. So
If you want to talk to re-election, go outside, we'll
But
talk
has
later,
your bid-
please.
Relax.
It's a fair question.
No, it's not.
It is a.
I'm sorry, you're interrupting, sir.
Be respectful.
Please.
¿Qué va a pasar mañana después de que presenten en la corte un documento?
Pues depende, como estaba explicando la abogada, la encargada de esta unidad, la Corte probablemente va a señalar otro día donde los dos, la defensa y nosotros podemos ir y habrá una evaluación de la evidencia, si hay alguien que se opone a esta moción que estamos, este proceso que estamos iniciando. También la Corte va a poder oír todo eso y la Corte toma la decisión final. Yes, ma'am. Yes, because we're going to make a decision one way or the other. It's just a question of what the decision is going to be.
Just giving
Yes.
you a timeline. If you are no longer in office, what happens in this case? The potential successor undo what you're about to file?
I don't think so. Once it's filed, it's filed. It's up to the court to take it from there.
You mentioned
Yes, I'm sorry.
Since you're obviously supporting the push for release here, how would that work? Would people from post-litigation, resentencing, would they go before the parole board to argue for their release? Or that
No. We have a policy that we only send victim services advocate if the victim or the victim's family wants that support. We don't send lawyers to our parole boards to relitigate a case. The parole board is fully aware of what the initial crime was, the crime that led to the conviction. Their work is primarily to evaluate whether they're rehabilitated and safe to be released, and that will be the way here.
Can you break down the timeline for us? Can we expect a hearing by the end of the year? You know, we might see
Nancy,
something on the
we
books?
don't.
I'm hoping to get it on calendar, depending on the defense preparedness. I'd like to see it go to hearing probably within the next 30 to 45 days at the most. There's not much to argue because it's kind of a collective.
Okay, there's one more question, please, but related to the case, not to elections. If you want to talk about elections, we'll do that.
Related to the case,
Yes, sir.
what would you like to say right now to Erik and Lyle Menendez?
What we like to say to them, and it's we, because it's not I've made the final decision, obviously, but we have a whole team that worked on it. We have a family here that wants to be reunited, is that we appreciate what they did while they were in prison. While I disapprove of the way they handle their abuse, we hope that they not only have learned, which appears that they have, but that if they get reintegrated into our community, that they continue to do public good. Thank you so much, everyone.
Thank you so much.
Thank you.
Thank you. Thank you so much.
All right, you've been listening to District Attorney George Gascón recommending resentencing for the Menendez brothers. It is something that we've been waiting to hear for quite some time. And we do have a quick programming note to tell you right now. Today's episode of General Hospital can be seen in full at 2:06 a.m. tomorrow morning, so you can set your DVR for that. We just wanted to get that housekeeping out of the way.
So a lot to unpack, and we will get into this with our legal expert in a moment. But you did hear there towards the end, during the question and answer session, a little bit of angst, a little bit of confrontation between the district attorney and those reporters asking about this in relation to the election. Oddly enough, during this press conference, we were given a statement from Nathan Hochman, who is also running for DA in the election that is coming here in November. And we talked with the expert, with Joshua, before this about the perception of the timing and all of that. And it was interesting that Nathan Hochman has not taken a position on what he would do regarding to this case. But in his statement, in part, I'm going to read from it. It says, by releasing it now, Gascón has cast a cloud over the fairness and impartiality of his decision, allowing Angelenos to question whether the decision was correct and just, or just another desperate political move by a DA running a losing campaign, scrambling to grab headlines through a made-for-TV decision. Angelenos and everyone involved deserve better. Again, that from Nathan Hochman, who is Gascón's opponent in this. But it is to be noted in this statement, he still does not take a position on what he would do given this case presented to him.
Right, and DA Gascón saying that he will file tomorrow, and now it will be up to the court to decide if they are, in fact, resentenced.
Joshua Ritter is still standing by. He is our legal expert. And Joshua, thank you so much for sitting with us before. The question I have now, it is very interesting what Gascón has decided when you look at the language of it. And he specifically mentioned it later. He did not think, he was not going to reduce this down all the way to manslaughter. He kept it as a murder charge. He kept it as premeditated. And the prison sentence would have been 50 years to life. However, as you mentioned, they still would have satisfied the sentence if the judge ultimately agrees with what Gascón is requesting.
Yeah, it's a very interesting move. A little bit of a curveball, because I think everyone was expecting that his choice would be between, just opposing any kind of resentencing or actually resentencing to manslaughter. What he's done here is he said he'd like to keep it at murder, but he's going to essentially a request of the court to remove the special circumstances from the case. So the special circumstances in this case, I think it was multiple murder and murder for financial gain. Those make a case eligible for the death penalty, or in this case, they were sentenced to life without the possibility of parole. But by removing those special circumstance allegations, it makes it a kind of normal first-degree murder, if there is such a thing, but that would be 25 to life, or 25 to life on each count, 50 to life. And then he explained that given their age and sentencing guidelines, it would actually make them eligible for parole today. So the interesting thing about it, to our discussion earlier about the timeline, is this does change things a bit, because even if the court does make an order to resentence them, a decision about their release is not immediately made until it goes in front of a parole board, who then has an opportunity to review and in any parole hearing either request that they are paroled or deny their ability to parole at that time, but they would still be able to petition for parole at a later date.
You mentioned the age of the brothers, and Gascón mentioned since they were under 26 when they were sentenced that they were eligible for youthful parole. Has that always been in place?
I think that is something new since the time of the murder. So I think what he's asking is that we use these kind of new guidelines considering their age at the time of the murder in conjunction with his request to have those special circumstances removed. The setup being is that the end result is it's interesting because it makes them eligible for parole, but leaves the decision on whether or not they are released outside of the hands of the DA's office and even the judge.
Yeah, that's to me a new thing, that we thought the whole narrative coming in was home by Thanksgiving, and that was a narrative. So what you're saying is they could he's in a sense punting. The judge could also punt and it now goes to the parole board, which for the Menendez brothers means we're still in prison until we get a parole hearing. Is that right on my read on what's happening here?
No, you are right. The actual decision, that ultimate decision that they're most concerned with, who's going to release us, is no longer now in the hands of the DA or even in the hands of the judge. The judge is just going to make a decision on sentencing, but that sentencing doesn't even really give them credit for time served, because all it does is then make them eligible for parole. Well, that then turns it into a parole board decision. So they're the ones who will ultimately make that decision. As far as the timeline goes for that, it's anyone's guess when they actually sit to review this case. When I'm not an expert on their guidelines as to when somebody is eligible, when is their first hearing, or how any of that works. But you're right, as far as what we were discussing earlier about a quick decision and the next order the judge could make would be release. That's all kind of out the window now. If the judge even is on board with this resentencing, it's still going to have to go in front of a board hearing.
And Gascón sort of laid some groundwork for that board to talk about the path of rehabilitation and redemption, and that the boys have, men now, have made life easier for others, and including groups to deal with untreated trauma. So that will go into part of the decision if they become paroled.
Yeah, absolutely. Yeah, and listen, with the decisions that the parole board has been making recently, and with no opposition obviously coming from the DA's office in regards to parole, they're supporting their parole. I imagine if they're supporting this decision, you would expect that they would have a very favorable opportunity at a parole hearing. But as far as the timing of when that hearing would take place, it's a little more difficult to guess. Whereas you heard that assistant DA mention that she is hoping to have this hearing on the resentencing within the next 30 to 45 days, because one little wrinkle she threw in there is they want to have a decision on this before they are required to argue the habeas, so that the defense is not in a position of still having to worry about that habeas petition if they already have their issue resolved with this resentencing.
So now, as we start talking about this resentencing, and remember, before we talked about Milton Anderson, the brother of Kitty Menendez, who has filed an amicus brief already. When you talk about what's about to happen in court, and then we add on that this is ultimately going to go to the parole board, he's going to have an opportunity multiple times now, correct? And by the way, it was a noticeably absent discussion in this press conference here. They didn't mention this amicus brief already filed that I heard. And so how or what do you think goes on, or logistically what happens there?
Well, as far as you were saying, the amicus or people opposed to this, what you're saying is absolutely true, and what we were discussing is true. They will still have an opportunity to be heard at this resentencing hearing. If that is granted, and they do go along with Gascon's suggestion that they're sentenced on a murder charge but less than life without parole, and that is handed over to the parole board, they will then be given an opportunity to be heard by the parole board as well. So you're right. Their voice will certainly be heard throughout this whole process moving forward.
Were you surprised?
The habeas,
go ahead.
Sorry, but the habeas is just this kind of side adventure where that's what originally was filed last year, and that's still pending. And that's not what Gascón is answering today. So what they were saying is that they want to try to resolve this before that habeas deadline, so that that doesn't affect the defense having to still argue the habeas, if that makes sense, I hope.
Mm-hmm. Were you surprised that the DA brought in the family members as almost like an impact statement before the hearing? Did this surprise you for this press conference?
I was surprised that he brought them in when he said that he hadn't even really finalized his own decision until about an hour before the press conference. That was shocking to me. I thought the fact that they even called this press conference meant that he had already made a decision, and he knew it was something that he wanted to share with everyone and had invited family members. So the fact that he was just letting people know minutes before he actually told the rest of the world was kind of shocking to me.
Yeah, according to him, he was making his decision at the time the press conference was supposed to begin at 1:30. So yeah, that was interesting.
But part of that is relatively hard to believe, and I don't want to go too far in the criticism or jumping into someone's mind, but to have them speak at this press conference seems a bit hard to believe that he hadn't. Here's what I would say. It seems to me, Joshua, that he was saying he didn't know what his decision was going to be, whether it was the manslaughter, whether it was the murder, whether it was to take it to the parole. He was still in debating even within his office. So I feel like there's reason to believe that he knew he was going to make a decision that at least they'd be somewhat happy with, because having people plan to speak at the press conference where you completely had no idea what you were going to say seems very hard to believe.
That's a really good point. I mean, when he's saying he was undecided, there's many things he could have been undecided about.
Exactly.
Right. It could have been that he was undecided about the manslaughter. It could have been that he was undecided about this situation, which we had not really discussed all that much. But I think you're probably right. If he's inviting family members, he was at least decided about somehow supporting their efforts to have the boys released.
So the judge will get the recommendation tomorrow, apparently, when he files. How soon does the judge make a decision? Any speculation how long that will take?
Well, like that assistant DA was kind of trying to explain the timeline. They'll file it tomorrow. They'll request a date as soon as they can. They're hoping to push this within 30 to 45 days to have the hearing. So they are hoping. Their efforts are that within 30 to 40, which, by the way, in the criminal court system, 30 to 45 days is basically breakneck speed. So they're hoping to have this in front of a judge with a full-fledged hearing, both sides making their arguments and a judge making a decision within a month and a half.
How much does it help? And they even mentioned it. So this is an interesting thing to me. The COVID era allowed us to speed up court proceedings in many ways, because all of the parties don't physically have to be in a courtroom. You can do it remotely. You can do it via Zoom. Is that maybe a factor here? Because I don't know. She was mentioning tomorrow they're not all going to be there. They're just going to file it. So is there that possibility that some of this, because in many cases it's the beginning of the beginning, that it could be handled remotely?
I mean, one of the biggest reasons that you're going to get delay in the criminal system is trying to just transport the defendant who's in custody into court, especially one that's not being held in the local jail. They're in state prison off-site, hours away. So transporting them in for a simple hearing about picking a date is going to be difficult. And if they can do that over this system they call WebEx, which is essentially a Zoom type thing, that's going to speed things up, because then they don't have to deal with all of those logistics. But I believe for the actual hearing where the judge will make a decision on this resentencing, they will likely be physically in court for that.
Well, Joshua, we want to say thank you again, and if you could just stick around as we continue to talk about this. We did hear from the family members, and we had talked with our producers a moment ago that I think we have some of those statements re-queued. So again, we are working with you. We're taking you up to the top of the hour before Eyewitness News at 3, kind of letting you know what happened with George Gascón if you missed any of it. But he did make an announcement today that he is going to suggest a resentencing to murder charges, which again is not manslaughter, which is what many people had thought, which make them eligible for parole instead of life without parole. He also, at this press conference, had some of the family members who gave their support for G.A. Gascón.
Today is a day filled with hope for our family. We are here because District Attorney Gascón has taken a brave and necessary step forward by recommending a resentencing for Lyle and Erik. The DA's decision reflects the truth that is hidden for so long, and I am grateful for his leadership in making this choice. We stand united in our hope and gratitude. Together, we can make sure that Erik and Lyle receive the justice they deserve and finally come home. Thank you to District Attorney George Gascón for his courage and leadership. This step gives us all hope that the truth will finally be heard and that Lyle and Erik can begin to heal from the trauma of their past.
We are here today because District Attorney Gascón has taken a brave and compassionate step forward by recommending resentencing for my cousins, Erik and Lyle. and we wish to offer our deepest gratitude to DA Gascón. This decision is not just a legal matter. It is a recognition of the abuse my cousins endured, and we are grateful for the DA's leadership in putting justice over politics. We know this wasn't an easy decision, but is the right one. This is about truth, justice, and healing. It is time for Lyle and Erik to come home. And I ask all of you to join us in this fight for justice. We stand united in our hope and in our gratitude. Together we can make sure that Erik and Lyle receive the justice they deserve and finally come home. Thank you again to District Attorney George Gascón for his courage and leadership. This step gives us all hope that truth will finally be heard and Erik and Lyle can begin to heal from the horrors of their past. We hope this will also shed light and increase awareness and help others who have been victimized by sexual violence. Thank you all so much for being here today. We are grateful for everyone's support.
What we like to say to them, and it's we, because it's not I've made the final decision, obviously, but we have a whole team that worked on it. We have a family here that wants to be reunited, is that we appreciate what they did while they were in prison. While I disapprove of the way they handle their abuse, we hope that they not only have learned, which appears that they have, but that if they get reintegrated into our community, that they continue to do public good.
So we heard from the relatives of the two brothers, but we did not hear about the other side that it's opposing them getting resentenced.
We did hear a message of unity from the family members in attendance, but again, Milton Anderson, who is the brother of Kitty Menendez, has filed an amicus brief. He does not believe that the brothers should be resentenced. He does not believe they should be out. So there is some disagreement in the family. And then, of course, we heard today, and Joshua Ritter is still with us. You had mentioned that there were people in the DA's office that didn't agree with this. And I found it, one thing I did when I was watching the DA, I felt he looked exhausted. I felt you could see that this was a difficult decision. And he acknowledged as much when he mentioned that there was not universal agreement in the DA's office that this was the right decision. Some believed they should be immediate released, and some believed that they should spend the rest of their life in prison. And it was a striking moment to me of when you looked at him and heard him saying that, it felt as if the weight of this was just sitting on him. And I'm not taking a political side here. I'm saying that many people are struggling with what should happen with this case. This was a trial of the century, so to speak, early in the 90s, and that was back then they had a hung jury. So for people now to try to make a decision and know that they know what to do, I feel like Gascón really had an office that was 50-50, and he didn't really know what to do.
Yeah, it's an unenviable position for him to be in. I mean, but these are the big time decisions that a DA has to make, especially when you're where the buck stops is with him on these types of decisions. But you're absolutely right. I mean, you got to think too that you're right. It was two trials. They put a tremendous amount of effort into this 30 years ago. Blood, sweat, and tears went into what they felt was seeking justice, which was the verdict that they got in the DA's office, which was guilty, along with special circumstances, life without parole. And then to undo all of that, in some of the prosecutor's view, is a miscarriage of justice. And then you're right, there's also the contingent who felt that this was the right thing to do now and may have been the right thing to do back then. So again, it's one of those cases that this is why we're talking about it 30 years later. It has such a cultural impact because it continues to kind of confound us.
Joshua Ritter, we want to say thank you so much. You gave us so much insight on this. We appreciate you, and thank you very much for helping us out. And it is important to note, there will be no quick answer on this. There is going to be a presentation to the board, eventually the prison board and the parole board, I should say, and then we'll find out at that point.
Right, a lot more to come on this story. And we do have a quick programming note. Today's episode of General Hospital can be seen in full at 2:06 a.m. tomorrow morning. You can set your DVR for that, or whatever people do these days. Are there still DVRs? I don't even know. And you can stay with Eyewitness News for continuing coverage of the Menendez brothers case. We're going to have continuing coverage on this breaking story throughout the day, coming up on Eyewitness News at 3 next. You can also head to our ABC7 Los Angeles streaming channel right now for continuing coverage.
And it is important to note, again, heading into this press conference, we thought, we were given indications that it would be reduced to manslaughter. Again, DA George Gascón announcing about 30 minutes ago that he will ask for resentencing on murder charges, which would mean 2 murders. The brothers would be sentenced in this resentencing of 50 years to life, which would mean they would be eligible for parole. And that means, as you heard from Joshua Ritter, still to come is a parole board that will ultimately decide if and when they get out of jail.
We'll see you coming up on Eyewitness News at 3 o'clock. Thank you so much for joining us.